Okay, today we got a lesson on discrimination, enforcement, and special situations. In our previous lesson, we talked about the different federally protected classes, and in this lesson, we talk about anti-discrimination enforcement and some of the special situations around protected classes. And in future lessons, we'll get into harassment, illegal harassment, and sexual harassment. A quick note for the lesson is that workers have rights. And like many rights, if you don't know your rights, you won't get your rights. Okay, there are governmental organizations that can help protect your rights, but those governmental organizations very rarely search out or search the worker out and look at the businesses. It is almost always worker-initiated complaints, the worker knowing what their rights are and if a company is violating their rights or not. So the definitions for today is the EEOC, Equal Employment Opportunity Commission, as one of the biggest federal government agencies that deal with workers' rights. And the next definition is reasonable accommodations. And that would be changes in the hiring process or workplace. So the workplace can fit with a worker's religion or disability. So first thing to talk about is major exceptions to the anti-discrimination laws. And two major exceptions come to mind. One is religious organizations are exempted from the federal anti-discrimination laws. However, that is only for religious organizations and for employees that are actually doing religious-related work. So what we have here is one more of those conflicting rights. We have the rights of a religion to organize their own religion in how that religion is acted upon, taught, spread, done. And we have the rights of people to engage in the workforce without discrimination, okay? So we have to value those rights and see which one would win out if there's a conflict. And in particular cases of religious organizations, in the act of the employees doing the religious-related work, they are exempt from the anti-discrimination laws. And some examples of that. One would be, so let's give two examples of that. So number one, in some religions, only men can be the religious officials, and there's religious official schools to learn how to do that, and they do not accept women. And so that is not considered discrimination under the federal guidelines because it is a religion following its own religious rules to get a worker that is going to engage in religious-related work. Another example to show where this applies is religious schools. So if there's religious schools, you do not have to be of the religion to work there as long as it's something that's not religious-related. So if there's a religious school and one of the classes or in the class, part of the class is teaching the religion, that teacher can be, the school can say, we only want of our religion and no other religion needs apply, and it's not discrimination. But someone working in the, let's say, cafeteria or a secretarial or a janitorial aspect of the school, they could not put in that religious test, and those jobs must be open for people of all religions because those jobs are not doing the actual religious-related work. Okay. And the second major exception is Native American tribes. There are many federal laws and state laws and rules that do not penetrate into the autonomous groups of Native American tribes, okay? Just certain United States laws do not affect Native American tribes. So all these anti-discrimination protections in these protected classes did not come out all at once, although a lot of them came from the Title VII of the Civil Rights Act in the 1960s. Not all of them came at the same time. So from multiple different acts of Congress and multiple different venues from our government creates these protected classes. So Title VII of the Civil Rights Act in the 1960s has quite a few protected classes. Title IX deals with sex discrimination. Americans with Disabilities Act, the ADA, covers Americans with disabilities. There was an Age Discrimination in Employment Act, I think in the late 1960s, 1970s. This gets the age over 40. Sometimes these protected classes are expanded by the Supreme Court rulings. For example, the protected class of sex was first meant for male and female. Anti-discrimination, no discrimination based on male or female, but Supreme Court rulings extended that to sexual orientation. And recently, the Supreme Court ruling extends gender expression for specifically, I think, from the case trans man, trans woman, as part of the protected class sex. So Supreme Court can add depth and breadth for the rulings of what classifies under a protected class. And also executive presidential orders to their departments, okay? So the EEOC is kind of under the presidential executive branch, and so presidents can add orders like the EEOC. And also the executive branch has a Department of Education, which can set up rules on how they follow Title IX and such like that in schools. So the executive branch of the federal government can also alter the focus of the legal system in enforcing anti-discrimination laws. And of course, Congress could make any new anti-discrimination laws they want. They could go through the House and the Senate and make a whole new law if they want, which is where the Civil Rights Act and Title IX came from, was from originally Congress. So all the acts and all the laws are one thing, but it's really about enforcing the laws, okay? Because if a law's on a book and no one enforces it, is it really a tree falls on a law? Is it going to be enforced, right? It's the age-old question. So you need agencies to enforce these laws. And there are many different agencies that will enforce anti-discrimination laws, okay? There's state departments, because every state has some anti-discrimination laws in it. So there's departments within every single state that their job is to take complaints and look into situations of discrimination. And there's federal departments. There's at least a couple that deal with workplace complaints for various reasons. But the federal agency that is the most involved in harassment, sexual harassment, and discrimination complaints is the EEOC, the Equal Employment Opportunity Commission. And it's in its name, right? It's designed to make sure workers have equal employment opportunity under the existing laws. So, what does the EEOC do? Well, there's branches of the EEOC. There's offices in every single state, and there might be 2 or 3 in a state, or just 1 in a state. The EEOC is populated by workers, and those workers take complaints and investigate complaints, okay? So let me describe the process, because I actually went through the process at one time. The EEOC will take a complaint. They will then investigate. They will take all the information from the worker who thinks they're being discriminated, harassed, or sexually harassed. They'll take all the information. They will then contact the business or government entity, because if it's a government employer, they're still going to investigate. It's not just the private sector. And the EEOC will get the other side of the story and say, hey, you've got a complaint. Let's hear what you have to say. Now, at this point, the EEOC might determine whether there is discrimination or not. If they determine that there's discrimination, well, first, if the EEOC says discrimination didn't happen, sexual harassment didn't happen, then it's done. Then they send a letter to the person who made the complaint saying, we're not following up with this. We don't believe it happened. You still have the right to sue in court if you want to, but we're not going to be involved. That's if the EEOC thinks there's no case. If the EEOC finds illegal discrimination, harassment, or sexual harassment, they can then either mediate or take the company or government to court. Mediate would be everyone gets together and they find a solution to the problem. And the solution to the problem usually means compensation, money compensation, maybe back pay, fixing the rules that were violating the law. Okay, so basically fix the situation and compensate the person who was hurt. And sometimes they do it without the court. Everyone's happy. The whole thing gets fixed, hopefully. If the company doesn't agree to a mediation or it fails to satisfy everybody, the EEOC in civil court can take the company to court, and it's a lawsuit. And it goes before a judge and possibly a jury. And that also can result in fines for the company, dollar awards to the person who was hurt and discriminated against, and the company might be forced to make rule changes. Or the courts would find that there wasn't discrimination, and the EEOC and the worker would lose. And finally, for enforcement, even if no government agency is involved, although government agencies are free to use, so it's always good, I think, to go to a government agency to see if they will investigate, individuals are always free to sue in civil court. And once again, an individual would get a lawyer and would take the company to court and present a case for discrimination. And if the company is found guilty, fines, dollar awards, and possibly rule changes. So we've got an interesting facet of the workplace that sort of fits into anti-discrimination laws. Not so much that it is discrimination, but under the idea, if you go back to why we have anti-discrimination laws, to allow full participation of people in the workplace, in the economy, okay, and not limited by things they really can't control. So part of that is to say, okay, well, can we make the workplace more accessible to people with disabilities and all religions? For example, there's certain practices of religions that would make some workplaces, people practicing the religion wouldn't be able to do the job because a small part of their job, would conflict with their religious practices. Similarly, there could arise a situation where someone's mental or physical disability there's a small part of the job where they could not do because of the mental or physical disability. Now, notice I've been using the word small part of the job. That'll make sense in a minute. So the law basically says we got a worker who wants to work, that wants to participate fully in the economy, in the workforce, but there's this small thing that's stopping them because it's conflicting with their religion or their disability, mental or physical. So the federal law says, well, then the business has to come to an accommodation to remove that small barrier so the person can fully engage in the workforce. Now, perhaps here is a good time to say most of the protected classes are something that someone's born with, into. It's who they are. They can't change no matter what. And then when you look through it, you would see, well, religion. Well, is not religion a choice? Well, a couple things on this. Number one, the United States was founded on freedom of religion, so religion has always been recognized as one of the basic freedoms of somebody in the United States. Religion and speech and freedom of speech have a huge importance in a person's identity and inalienable rights. And so, number one, it's woven into the fabric of America that the religion is super important to someone. And number two, technically religion might be a choice or not. It might be a choice, but people are typically born into a religion. They grow up in that religion, so much so it doesn't exist as like a choice. It's not like what I'm going to eat for breakfast, right? It is something that people in general have been exposed to from the beginning of their lives. It is a part of their identity. So just saying, oh, well, I'm not going to be this religion anymore, isn't really a choice because it is such a big part of their identity, the reasoning goes. And so those are two ideas of why religion, whereas someone says, oh, well, it looks like a choice, you can choose. Under how it's viewed legally, it's less of a choice, and so it can be put into that protected class for the arguments that I had just given. Now, these reasonable accommodations are for during the hiring process and once someone is on the job. Now, a huge major limitation to this is that, let's go here, that the accommodation has to be reasonable, okay? And reasonable is defined as it can't create an undue hardship on the employer. And undue hardship is further defined as a financially hard, tough on the employer or disruptive to the business. Okay, so let's give some of the most famous examples. Let's say a religious accommodation. If a religion requires its participant to pray certain times during the day, it is a reasonable accommodation for the workplace to arrange the breaks of that employee around prayer time. That's a reasonable accommodation. Let's say there is a holy day and the work has scheduled an interview on that holy day, because perhaps the business is still working on that holy day, but the person's religion, it's a holy day. A reasonable accommodation is to change the interview date so it doesn't fall on a day of rest or a day of holiness. That would be a reasonable accommodation. Does it create a financial burden on the company? Probably not. It doesn't really cost the company that much for the breaks or the changing of the interview day. Is it markedly disruptive? It doesn't change the business whatsoever if the person takes their break at 10 or 10:30 or 11. Okay. It is on a case-to-case basis. So what is reasonable for one company might not be reasonable for another. Okay. So if someone needs an interpreter, let's say a sign language interpreter, that's one of the classic examples, and they're a worker, and there's going to be a big meeting, and it's a really big company, it is reasonable to say, this is a big meeting of hundreds of employees, it is reasonable to say that the company should hire a sign language interpreter for that meeting. Whereas if the business was made up of maybe 4 people and they don't make a lot of money during the year, just enough to get by, hiring a sign language interpreter for 1 or more days might not seem financially reasonable. If someone, let's say someone's height is labeled as a disability, a reasonable accommodation would be to raise up the floor in the place where they might be working. Let's just say behind the counter with the cash register to take orders. That is entirely reasonable. It doesn't cost a lot, and it has to legally be done, so the person who is shorter has the right to participate in the workplace. An employee must be able to do the main idea of a job. An example is used a lot of the time. If the job is firefighter and the requirement, the bona fide occupational qualification, is that someone has to be able to suit up and be mobile and run into a burning building and save people, and that's like the qualification of the job, it is not discrimination to not hire someone in a wheelchair. That's not discrimination. There's no amount of reasonable accommodation that could help that person fulfill the bona fide occupational qualification. Similarly, if someone has a physical disability that prevents them from swimming effectively enough, they cannot be a lifeguard. That's not discrimination. If there was a reasonable accommodation, fine. But if there's no reasonable accommodation, it's not discrimination, and it falls under, there's just no way to help the person fulfill the BFOQ. And sometimes this is based on a case-by-case basis. Let's take 2 butcher shops, one in a very large store with multiple workers, and one just 2 employees or 1 employee. If you have someone with a religion that precludes and they can't touch certain animals, in the large butcher store, there could be a reasonable accommodation, and they could just not have to deal with that 1 animal, and they could still fulfill the BFOQ. In the small butcher store, where there's only basically 1 employee, and that employee has to handle every animal, there's no reasonable accommodation if they can't find one, and then we'd say the person can't fulfill the BFOQ. So to sum up and finish, reasonable accommodations must be made in the workplace and the hiring process to accommodate someone's religion or disability, mental or physical, as long as the person can fulfill the BFOQ of a job and the accommodation is not too financially disruptive to the business. A reasonable accommodation legally must be given.